The Industrial Court of Trinidad and Tobago.
Good morning, everyone. The Chief Justice of the Republic of Trinidad and Tobago, Mr. Justice Ivor Archie, Senator the Honorable Reginald R. Moore, Senior Counsel, Attorney General, and Minister of Legal Affairs, the Honorable Stephen McClatchy, Minister of Labour, the Honorable Mr. Justice Adrian Saunders, President of the Caribbean Court of Justice, His Excellency Juan Anibal Barria Garcia, Ambassador of the Republic of Chile, His Excellency Peter Cavendish, Ambassador to the European Union to Trinidad and Tobago, Mr. Shante Moore, Chargé d'Affaires ad interim of the United States Embassy in Trinidad and Tobago, Mr. Rudy Indarsing, Member of Parliament for Couva South, His Worship Alderman Joel Martinez, Mayor of the City of Port of Spain, Ms. Diane Qualis, Director of the United Nations Economic Commission for Latin America and the Caribbean, Mr. Dennis Zulu, Director of the International Labour Organization Office for the Caribbean, Her Honor, Mrs. Donna Crowell Raphael, Chairman of the Equal Opportunity Tribunal, His Honor, Mr. Sunil Sukraj, Chairman of the Environmental Commission, His Honor, Mr. Herbert Sovereign, Vice President, and His Honor, Mr. Lawrence Achong, Chairman of the Essential Services Division of the Industrial Court of Trinidad and Tobago, Judges of the Industrial Court of Trinidad and Tobago, Dr. Sterling Frost, Lay Assessor of the Industrial Court of Trinidad and Tobago, members of the Inner Bar, representatives of the United Nations Development Programme and International Labour Organization Office for the Caribbean, Mr. Keston Nanku, Chairman of the Employers Consultative Association, heads and representatives of trade unions, heads and representatives of employers' organizations, practitioners of industrial relations, specially invited guests, members of the media, good morning. The Industrial Court of Trinidad and Tobago, a superior court of record, was established in 1965 pursuant to the provisions of Section 5.1 of the Industrial Stabilization Act, and became the first industrial court in the English-speaking Caribbean. The Industrial Stabilization Act, for the first time, provided for compulsory arbitration among social partners, and the vehicle for this arbitration was the Industrial Court. The Industrial Court has jurisdiction to hear and determine trade disputes, to register collective agreements, and to hear and determine matters related to the registration of such agreements, to enjoin a trade union and other organizations or workers and other persons or employers from taking or continuing industrial action, to hear and determine proceedings for industrial relations offenses under the Industrial Relations Act, and to hear and determine any other matter brought before it pursuant to the provisions of the Industrial Relations Act. The principal role of the court is to settle unresolved disputes and other and trade unions representing the workers employed by employers under the Industrial Relations Act, the Retrenchment and Severance Benefits Act, the Maternity Protection Act, the Minimum Wages Act, and the Occupational Health and Safety Act. Apart from open court proceedings where they are adversarial in nature, the court offers non-adversarial approaches by way of conciliation to parties. There are two divisions of the court: the Essential Services Division and the General Services Division. There's also the Special Tribunal of the Industrial Court. The Essential Services Division is headed by His Honor, Mr. Lawrence Achong, an expert in the field of industrial relations. The President, Her Honor, Mrs. Deborah Thomas-Felix, and Vice President, His Honor, Mr. Herbert Sovereign, who are attorneys at law by profession, are members of the General Services Division. Apart from being the President of the Industrial Court of Trinidad and Tobago for the past 11 years, Her Honor, Mrs. Deborah Thomas-Felix, a judge of the International Monetary Fund Administrative Tribunal. She is also one of the experts of the International Labour Organization's Committee of Experts on the application of conventions and recommendations, and is the 8th President of the United Nations Appeals Tribunal. She is also the recent author of 2 books on labour law and good industrial relations. Over the past 10 years, there have been many innovations and transformations in the way the Industrial Court conducts its business. To name a few, the court has enhanced the case management and pretrial process. enhanced the processes of the court's registry documentation management system, digitized the library, installed interactive information kiosks and electronic signage, provided video conferencing services between north and south branches of the court, and expanded the court reporting technology and introduced wireless internet for all users of the court. Today, Her Honor Mrs. Deborah Thomas-Felix will deliver the feature address and will be joined by His Honor Mr. Herbert Soverell, Vice President, and His Honor Mr. Lawrence Achong, Chairman of the Essential Services Division. At this time, I invite us all to kindly stand as we welcome the procession of the President of the Industrial Court and the judges of the Industrial Court. Please be seated.
Good morning, everyone. Yes, I do my protocol list. I don't have a comprehensive protocol list, so bear with me. The learned Chief Justice of Trinidad and Tobago, His Lordship, Mr. Justice Ivo Achi, Senator the Honorable Mr. Reginald Amor, Attorney General of Trinidad and Tobago, the Honorable Stephen McClatchy, Minister of Labor, the Honorable Mr. Justice Adrian Saunders, President of the Caribbean Court of Justice, Their Excellencies and members of the Diplomatic Corps, His Worship, the Mayor, Mr. Joel Martinez of Port of Spain, Mr. Dennis Zulu, Director of the ILO's Office for the Caribbean, Her Honor Ms. Donna Prowell, Chairman of the Equal Opportunity Tribunal, His Honor Mr. Sunil Sukraj, Chairman of the Environmental Commission, the Vice President of the Industrial Court, His Honor Mr. Herbert Soverell, the Chairman of the Essential Services Division, Mr. Lawrence Achong, judges of the Industrial Court, Dr. Sterling Frost, Lay Assessor of the Industrial Court, members of the Inner Bar, representative of the United Nations Development Program, and representatives of the ILO's office, Chairman of the Employers Consultative Association, Mr. Keston Nanku, heads and representatives of employers' organizations, heads and representatives of trade unions, practitioners of industrial relations, specially invited guests, members of the media. Good morning to everyone. These are interesting historic times. This is a time when the COVID-19 pandemic continues to have a profound and catastrophic effect on our lives, and it remains a major public health issue in every corner of the globe. It is the time when there is global inflation, which is mainly driven by increases in food and energy prices and disruption in the supply chain. This is also the time when issues like climate change, economic inequality, poverty, and broken healthcare systems loom large. In addition to these troubling global interlocking issues, we continue to be plagued in Trinidad and Tobago with murders and violent crimes, especially crimes perpetrated against women. This year, our Twin Islands state celebrates 60 years as an independent nation and 46 years of republicanism. As I reflect on the Jubilee celebration and what we have achieved as an independent nation, I cannot help but ponder on the words of the ILO's Declaration of Philadelphia of 1944 and that of our independent Constitution of 1962. The Declaration of Philadelphia is a very important part of the history of the world, and it promotes key principles which are embodied in law in many countries across the globe. The main principles of the Declaration, which I wish to highlight today, are labor is not a commodity. Freedom of expression and freedom of association are essentials to sustained progress. Poverty anywhere constitutes a danger to prosperity everywhere. The war against want requires to be carried out with unrelenting vigor within each nation and by continuous and concerted international effort in which the representatives of worker and employers enjoy equal status with those of governments, joined with them in free discussion and democratic decision with a view to the promotion of the common welfare. All human beings, irrespective of race, creed, or sex, have the right to pursue both their material well-being and their spiritual development in conditions of freedom and dignity, of economic security and equal opportunity. The attainment of the conditions with which this shall be possible must constitute the main aim of national and international policy, unquote. There is a marked similarity in the language of the Declaration of Philadelphia and that of our independent Constitution. I did, in my quiet moment, wonder whether in 1962, the new Parliament, the new post-independence thinkers, and the lawmakers reflected on this remarkable declaration when drafting our independent Constitution. Ours is a Constitution which says, whereas the people of Trinidad and Tobago have affirmed that the nation of Trinidad and Tobago is founded upon principles that acknowledge the supremacy of God, faith in fundamental human rights and freedoms, the position of the family in a society of free men and free institutions, the dignity of the human person, and the equal and inalienable rights with which all members of the human family are endowed by their Creator, respect the principles of social justice, and therefore believe that the operation of the economic system should result in the material resources of the community being so distributed as to subserve the common good, that there should be adequate means of livelihood for all, that labor should not be exploited or forced by economic necessity to operate in inhumane conditions, but that there should be opportunity for advancement on the basis of recognition of merit, ability, and integrity, have asserted their belief in a democratic society in which all people may, to the extent of their capacity, play some part in the institutions of national life, and thus develop and maintain due respect to lawfully constituted authority, recognize that men and institutions remain free only when freedom is founded upon respect for moral and spiritual values and the rule of law, unquote. There are very similar key words and expressions in our Constitution, and that of the Declaration of Philadelphia. Expressions such as freedoms, labor is not a commodity, labor is not to be exploited, social justice, common good, common welfare, dignity, and spiritual values. Indeed, it is clear that the rule of law, equal rights and freedoms, the quest for peace, social justice, and the socio-economic development of all people, with labor as the backbone, are really at the root of the preamble of our Constitution and also that of the Declaration of Philadelphia. These rights and principles promote qualities and values that are fundamental to the development and advancement of any nation. Today, I invite the social partners and all stakeholders to reflect on the words of our independent Constitution and on the achievement and advancements we have made as a nation over the past 60 years, and also to give some thought to the principles enunciated in the Declaration of Philadelphia. Given the loss of human life worldwide, the continued public challenges, the unprecedented impact in the supply chain, and the devastating effect in the world of work of the COVID-19 pandemic, and also the public health measures which have been adopted worldwide in response to this pandemic, our country, like the rest of the world, continues to be severely impacted by the effects which those public health measures have had on the business community, on workers' health, their income security, and on the labor market in general. In the midst of all of this, can we possibly consider moving forward as a nation with our economic and social development plan without social dialogue, particularly collective bargaining and the meeting of minds? In May 1963, exactly 9 months after it achieved independent status, Trinidad and Tobago ratified its first ILO conventions. The conventions of which I speak are the Freedom of Association and Protection of the Right to Organize Convention, and that's Convention 87, the Right to Organize and Collective Bargaining Convention, Convention 98, and the Forced Labor Convention, Convention 29. These three conventions are among the fundamental conventions of the ILO, and they may be of more importance to us today than they were in 1963. It is noteworthy that in 1963, the government of the day understood the value of the right to organize and to engage in collective bargaining, and those rights were subsequently included in our national laws. For the past few years, I have been using this forum to emphasize the importance of social dialogue, whether it is bipartite or tripartite dialogue, with emphasis on collective bargaining. Today, I wish to revisit that discussion because of the importance of this topic at this time in this country's history. Permit me first to repeat what I stated last year, and I quote, "We can agree that the world of work as we know it will not be the same because of the social and economic impacts of this pandemic. Therefore, there may be the need for employers and workers' representatives to re-examine and revise the duties and the functions of some employees and to address new issues which may present themselves at the workplace. This, of course, could only be done after consultation with employees or if there is a union through the collective bargaining mechanism. I urge unions and employers to meet, to be open to dialogue and consensus, even if the discussion may initially cause a level of unease and discomfort. Always remember that social dialogue is a very important tool in industrial relations as we try to resolve these very troubling issues of common interest." Unquote. Social dialogue, as defined by the ILO, includes all forms of negotiation, consultation, or simply the exchange of information between or among representatives of government, employers, and workers on issues of common interest relating to economic and social policy. In Trinidad and Tobago, at the level of the workplace, there is a need for genuine, continuous bilateral discussions between trade unions and employers to address all issues, especially those related to changes in the modality of the work since the pandemic. As expected, throughout the pandemic, trade unions and employers alike sought the intervention of the industrial court for the resolution of issues. However, some of these issues could clearly be resolved by bilateral discussions. Please remember, a major component of the grievance process is dialogue. Therefore, the starting point should always be bilateral discussions with the intention to resolve the issues. There is much to be gained when parties meet and resolve their issues without a third party. The lack of genuine social dialogue about transformations and adjustments in the world of work since the pandemic by the key players in this country is evidenced by the large numbers of trade disputes, industrial relations offenses, and occupational safety and health cases which have been filed by the Industrial Court over the last 2 years. During the year in review, which is the 15th of September 2021 to the 14th of September 2022, 199 new cases with 1,099 new cases were filed at the Industrial Court. 133 cases more than the same period in 2020 to 2021, which recorded 966 cases. The court disposed of 797 cases this year, which is 240 less than the 1,037 matters disposed of for the same period last year. The disposal rate for 2021 to 2022 is 72.5%, which is 34.8 percentage points lower than the period of 2020-2021, when the disposal rate was 107.3. The total numbers of disputes disposed during the period in review are as follows: 193 judgments, 312 cases were withdrawn, 263 cases settled through conciliation and the bilateral process, and 29 cases were dismissed. Of the total number of disputes filed at the Industrial Court this year, 2021 to 2022, trade disputes remain the largest numbers of matters filed, with a total of 730, followed by retrenchment and severance benefit disputes, which is 124, and occupational safety and health dispute, 111, and 58 industrial relations offenses. The total number of new cases filed at the Industrial Court from March 2020, when the pandemic was announced, to the 14th of September 2022 is 2,516 cases. This is so despite the fact that some sectors were closed due to public health measures. These figures tell a story and suggest that there is a need for more discussions and agreement in the workplace. It can be posited that there are two very valuable lessons which we can take away from the experience of the past 2 years with the continued assault of the COVID-19 virus in the world. The first lesson is no man is an island, and the second, particularly in times of crisis, is that we need to collaborate and be our brother's keeper while we sing from the same hymn book. I therefore urge social partners to work together to continue to contribute to this nation's further development. Step back from the deeply entrenched positions which have borne no fruit thus far, and take a leap of faith to embrace genuine consultation with the person seated on the opposite side of the table. I pause to give a brief account of the working of the Industrial Court for the period the 15th of September 2021 to the 14th of September 2022. The court continues to build capacity. This year, the court collaborated with the Judicial Education Institute and conducted training with judges on judgment writing. This training was delivered and facilitated by Justice Gregory Smith, Justice of Appeal, and my special thanks to the Honorable Chief Justice and Madam Justice Gillian Lucky for making arrangements for this to happen. As reported last year, case management continues to be conducted virtually. However, conciliation hearings have been reverted to in-person hearing due to a number of reports of dissatisfaction from stakeholders about how impersonal the new virtual process had been and the need to be physically present at these sessions. So we now have conciliation in person again. There have been an upgrade in the facilities in San Fernando, and we continue to rely on the chairman, Mr. Anthony Roberts, and staff of Sawo Barataria Regional Corporation to assist in sanitizing the Port of Spain building, and my sincerest thanks to the corporation for the kind assistance and support. The court has also been provided with IT equipment, such as servers, as we recover from the past 2 years and we try to update our technology. With respect to Tobago, over the past 2 years, access to justice for the people of Tobago has been difficult. Due to the pandemic, the serving of processed documents from the court came to a halt. Litigants were impeded from traveling from Tobago to Trinidad, and even in case management, there were connectivity challenges. This has resulted in a backlog of cases from Tobago. I hope in this new law term to have open court sessions in Tobago during the August vacation to clear up some of the backlog. Her Honor, Ms. Sandra Ramparas, who served as a judge of the court for more than 2 decades, has retired, and so has the registrar, Mr. Noel Innes. On behalf of the Vice President, the Chairman of the ESD, judges, members of staff of the court, I wish to extend best wishes to them on their retirement and on their new chapter in life. I wish to welcome the new registrar, Mr. Kevin Swan, who joined the staff last year. Looking at the future, in 1965, some 57 years ago, the Parliament of Trinidad and Tobago enacted legislation to provide for the compulsory recognition by employers of trade unions and organization representatives of a majority of workers, and also for the establishment of the Industrial Court. The then Prime Minister, Dr. Eric Williams, had this to say about the industrial climate of the country at the time, and I quote, "In the last 5 years, 1960 to 1964, there have been 230 strikes in the country, an average of 46 a year. The number for the year 1962 was 75. The number of workers involved in these strikes in 5 years was 74,574, an average of 15,000 per year," unquote. We have come a long way from those days. As we look to the future, collective bargaining is the only progressive way forward to achieve sustainable development and to arrive at consensus on the new modality of work and the future of work. It is very important that the collective bargaining process, which is mandatory under the laws of Trinidad and Tobago, takes center stage in workplace relationships, as it provides an effective means for employers and workers to tackle the new challenges in the workplace. The COVID-19 experience has shown that there is an urgent need for the strengthening of articles and clauses in collective agreements to treat with existing issues of occupational safety and health at work, and to make provisions as far as possible for any public health future crisis which may occur in the workplace. In addition, social partners may also want to re-examine and negotiate new articles and clauses to deal with provisions for paid leave and healthcare benefits in collective agreements. There is no doubt that a continued collaboration between employers and trade unions is very important for policy making at the workplace, and that collective bargaining is key to forge an inclusive, sustainable recovery post-COVID-19. Social partners should always strive to utilize the collective bargaining process as a starting point, meet in good faith, have genuine, open discussion and negotiations where possible, attain consensus in on workplace issues such as working conditions, pay and remuneration, and productivity, among other things. Currently in Trinidad and Tobago, public sector negotiations are taking place and there is much anxiety among workers. It is noteworthy that several new collective agreements have been finalized in the public sector and the private sector over the past years. In 2091, let me read it over, please. It is noteworthy. It is noteworthy that several new collective agreements have been finalized in the private sector over the past years. In 2019, out of a total of 40 new collective agreements registered, 38 were from the private sector. In 2020, there were 55 new agreements registered, 50 from the private sector. In 2021, 104 new collective agreements were registered, with 85 from the private sector. And this year, so far, 19 new collective agreements have been registered, 73 of which are from the private sector. Last year, I mentioned the large number of breakdown in negotiation cases which had been filed at the court for the period 15 September 2020 to 14 September 2021. That figure was 42. This year, a significantly smaller number of matters were filed for the period September 2021 to September 22. That number is 23. I have always held the view that collective bargaining for new collective agreements must be contemporaneous to the period under review. One wonders what value can be derived by workers and also by employers when they negotiate for new terms and conditions some 7 or 10 years after the period in review. Often, the new negotiated terms bear little or no relevance to the past. Indeed, there is nothing which prevents one of the partners engaged in collective bargaining from reporting a breakdown of negotiation either to the Minister of Labor or to the Minister of Finance, while at the same time commencing fresh negotiations for a collective agreement for the ensuing new period. There is no reason, in my mind, to wait until the expiration of 2 or 3 terms before making formal reports of a breakdown in negotiations. I do hope that some thought and consideration will be given by employers and trade unions, both in the public and private sectors, to engage in collective bargaining for new collective agreements contemporaneously. Now let us look at the burning issue in the room, Tripartism and the National Tripartite Advisory Council of Trinidad and Tobago. I'm looking around to see the members of the committee. The tripartite mechanism, which is embraced by countries worldwide, regardless of their legal system, is an extremely important and useful tool to assist in the resolution of the myriad issues in the world of work. And those who are involved in tripartism know that the model is Singapore and Barbados. Through this mechanism, representatives of workers, employers, and the government each have an equal voice in decision-making. Tripartism is also key in treating with the labor market and its volatility. It will be of great assistance in times like this, when personnel from the ILO, the UN, and world leaders gather to address what is called the interlocking crises that we consider tripartism. Last year I said the following, and I quote, "It is public knowledge that the National Confederation of Trade Unions has withdrawn from the National Tripartite Advisory Council for what they consider to be good reason. However, this is a time in our nation's history where there is a need for the workforce to be guided by the decisions of the tripartite leaders. The current unprecedented challenges in the world of work, which have been presented by this pandemic, require strong leadership to assist and to navigate the workforce through these difficult, uncharted, and mirrored issues, and also to assist in stabilizing the labor market. The workforce needs to be reassured and comforted in the knowledge that the tripartite leaders, the government, the employers, and the trade unions are engaged in regular discussions with a view to reaching agreement on the path to be followed in the workplace to address the issues created by the pandemic. This much-needed guidance can only be achieved in a climate of mutual respect and compromise facilitated through social dialogue. This may be the time for the National Tripartite Advisory Council to revisit its working mechanism and for the Federation of Trade Unions to reconsider the timing of their collective stance of non-participation in the Council. Additionally, the trade union movement and the government may wish to iron out their differences in order to begin meaningful consultation along with the employers on the effect of the pandemic on the world of work and on industrial relations over the past 18 months or so, and the role of the employer and workers' organization in forging a path of economic and social recovery for our nation during and after the pandemic," unquote. Since that address, I have received a range of perspectives from the employers and trade union representatives on the various issues which should be addressed and ironed out before the National Tripartite Advisory Council can meet and function effectively. From all accounts, it appears that trust continues to be the uninvited guest and absent at the table. We must not ignore the value of tripartite meetings and the importance of having an effective national tripartite council. As explained earlier, it is a fundamental tenet of tripartism that each of the social partners has an equal voice when they meet to address issues related to the economy and to the labor market. It is also accepted that through this considered approach, that they work together to assist in, and I quote, "the promotion of the common welfare," unquote, to coin a phrase from the Declaration of Philadelphia. It is my sincere belief that the problems which currently exist between the social partners who are members of the National Tripartite Advisory Council, though very troubling, are not insurmountable. Through my lenses, and I say this very respectfully, what is required is an understanding of how a tripartite advisory council works, what are its functions, and the appreciation of the important role such an organization can play in labor market development. I therefore repeat my call for constructive social dialogue between the tripartite partners with a view to strengthening the labor market and the workforce. It is imperative that the tripartite partners, who are in fact leaders in the world of work, set aside their differences and have that difficult but preliminary meeting and a much needed discussion on the elephant in the room with a view to resolve differences, to listen and to understand the different perspectives, and to agree to a structure of a viable working methodology at the level of the National Tripartite Advisory Council. There has been a growing number of protests in this country, several of which are centered on what is perceived as social ills and lack of social amenities. In addition, there have been protests related to working conditions, job losses, and negotiations for new terms and conditions at work. The Tripartite Advisory Council needs to get to work. We cannot get back to the era of strikes which Dr. Eric Williams reported to the Parliament in 1965. It is therefore in the national interest for the tripartite partners to meet, to have meaningful discussions, embrace their different roles to address burning issues such as poverty alleviation, job reduction, job losses, the closure of businesses, and social protection. This is not the time for government, employers, and trade unions to see each other as adversaries. It is the time to be partners working harmoniously to assist in the socio-economic development of our beloved Trinidad and Tobago. The country needs your input and your guidance to shape policy and to promote the rights of work and to strengthen dialogue on work-related issues. The way forward as we build and achieve as an independent nation and celebrate future milestones like 75 years of independence should be a path paved with nuggets, my words, paved with nuggets of effective social dialogue, sprinkled with tripartism and bipartism along the way, a path on which the practice of good industrial relations as a means to promote social justice, inclusive growth, decent wages, favorable working conditions, and sustainable businesses is at the core of our sustainable development policies as we forge ahead. This is a crucial time in our country's history and development when we are recovering from a health crisis. Let us focus on the common good and on the common purpose while we work towards economic recovery and sustainable development with social dialogue firmly at the center. I'm reminded of the voices of two of our sages of Calypso, Black Stallion and the Merchant, when they exalt us. We can make it if we try, just a little harder. Come, my brother, come, my sister, let us build a nation together. Thank you, and may God bless this nation.
Please be seated. We'd like to thank Her Honor, Mrs. Deborah Thomas-Felix, the President of the Industrial Court, as she delivered the feature address at the ceremonial opening of the court's new term. We could show her appreciation with a round of applause once again for her deliberations. In concise summary, Her Honor, of course, underscored the importance of social dialogue. She drew on comparisons between Trinidad and Tobago's 1962 Constitution and the ILO 1944 Philadelphia Declaration, which spoke to the importance of social dialogue, freedom of expression. She also quoted the important virtue, poverty anywhere is a danger to stability everywhere. Her Honor also elucidated the issues of freedom, dignity, equality of treatment. She also spoke about the principles upon which this country is built and the importance of collective bargaining and social dialogue as important tools in industrial relations. In closing, Her Honor also spoke to the way forward, and if I may quote, "Let us be our brother's keepers, and no man is an island, and the way forward being sprinkled, replete with nuggets of social dialogue, and sprinkled with the elements of tripartism." At this time, we've come to the official end of this ceremonial opening. We thank you for your presence here on behalf of the members of the Industrial Court and, of course, those gathered here at the Industrial Court, Room 1. Those of you viewing on TV6, we thank you for being with us, and we wish you a safe and productive day.
That was the live broadcast of the special sitting for the opening of the law term of the Industrial Court of Trinidad and Tobago.